This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're doing another Man Bites Dog story where a fraudster's attempt at no-fault arbitration was stopped by the United States District Court, and why arbitration was stayed for suspected chiropractors' fraudulent, no-fault medical claims. In Government Employees Insurance Company, GEICO versus Didier Demesmin, MD, the United States District Court for the Eastern District of New York on October 23, 2024, dealt with a motion from GEICO that sought to enjoin defendants Manuel A. Mendoza, D.C., and Mendoza Chiropractic Office PC from pursuing certain no-fault insurance collection arbitrations or initiating new collection proceedings during the pendency of the lawsuit. GEICO provides personal injury protection benefits on a no-fault basis, which means that after an accident, insured drivers and their passengers are entitled to certain benefits for medically necessary health care services regardless of who was at fault. GEICO sued a group of healthcare providers who allegedly carried out an insurance scheme to obtain fraudulent no-fault benefit payments from GEICO. The United States District Court granted the motion based on its conclusion that 1, GEICO would experience irreparable harm absent a stay, and 2, that GEICO raised a serious question going to the merits, and 3, the balance of hardships tipped in GEICO's favor. Subsequently, GEICO requested leave to file a second amended complaint to add allegations concerning the Mendoza Defendants, which was granted. In total, GEICO seeks recovery of more than $5.9 million in wrongfully obtained benefits payments from the 3 groups of defendants, as well as a declaration that it is not obligated to reimburse defendants for outstanding no-fault claims. And after filing the second amended complaint, GEICO filed the present motion seeking an order staying all pending no-fault benefit arbitrations between GEICO and the Mendoza defendants and enjoining the Mendoza defendants from commencing new collection proceedings during the pendency of this action. GEICO, according to the court, will experience irreparable harm absent a stay. Irreparable harm is certain and imminent harm for which a monetary award does not adequately compensate the risk of inconsistent judgments in no-fault insurance disputes that can constitute irreparable harm separate and apart from the expenditure of time and money spent on parallel proceedings. As with the parallel proceedings brought by the Demesmin and the Canon defendants, the risk of inconsistent outcomes is great enough to establish irreparable harm. GEICO established irreparable harm because permitting arbitrations to proceed will subject it to a risk of judgments that may be inconsistent with future judicial rulings. GEICO's amended complaint details a complex scheme of fraudulent billing and referrals among the network of chiropractic providers. GEICO's allegations concerning the Mendoza defendants' role are well developed through numerous examples of charges billed without proper documentation or under suspicious circumstances, and a table of more than 45,000 suspected claims. The balance of hardship also tips in GEICO's favor because the Mendoza defendants have not established any hardship beyond a delay in reimbursement, and because the defendants will presumably be entitled to collect interest on their pending claims if they prevail, the delay does not outweigh the risk of inconsistent outcomes faced by GEICO. The Anti-Injunction Act prohibits federal courts from enjoining proceedings in state court except as expressly authorized by the act of Congress or when necessary in aid of its jurisdiction or to protect or effectuate its judgments. The AIA does not, however, limit the court's authority to enjoin ongoing private arbitration proceedings or the court's authority to enjoin defendants from initiating future state proceedings, and therefore GEICO's motion was granted and a preliminary injunction was issued, one staying all pending no-fault insurance collection arbitrations that have been commenced against GEICO buyer on behalf of the Mendoza Defendants pending the disposition of GEICO's claims in this action, and two enjoining the Mendoza Defendants and anyone acting on their behalf from commencing new no-fault arbitrations and litigations against GEICO pending the disposition of GEICO's claims in this. In my opinion, the United States District Court and other courts dealing with no-fault auto insurance claims has acted to help insurers defeat attempted insurance fraud, a crime in each state like New York and New Jersey, which became necessary because state prosecutors seemed to ignore the crimes reported to them by insurers like GEICO. It is essential that insurers be proactive against fraud, to shame the insurance fraud investigators in each state to do their job and prosecute the fraud perpetrators. Every insurer faced with similar fraud should emulate GEICO and sue the fraudsters to get your money back and to stay all arbitration proceedings while you're doing so. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 4,900 blog postings. You can also subscribe to the videos, which are free on rumble.com and youtube.com. And if you do, I'd appreciate if you click on the thumbs up button on Rumble or the like button on YouTube. And please tell your friends and colleagues about this blog and the videos and let them subscribe, since I have no advertising budget. And if you're interested in further detail about insurance, insurance claims, insurance fraud, insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.